So my interest in the book that I was talking about earlier, the Nine, which is right here. Um, it's it is very interesting. It's again, I'm just gonna read the title, the Nine, the inside the secret world of the Supreme Court by Jeffrey Tobin, which is very interesting book. Um, I would the reason I'm reviewing this book is I thought that American public should know what goes on in the highest court in this country because they have direct impact what kind of rights we'll have or if we have any rights and how those rights will be implemented. So the book discusses very interesting take and ideology on different philosophies of interpreting the law. It's called jurisprudence, and jurisprudence is a philosophy of law, and there's many different kinds that people look and interpret, and especially lawyers, judges, how they interpret the law, and it's all based on political political affiliations, political strategies that judges use, lawyers use. Yes, their training is pertained to interpreting the law, but their training is pertained to interpreting the law according to certain ideologies. And, like, for example, Justice Scalia, who is originalist, um, he passed away, was a few years ago or something, but he was originalist, and he believes that we should interpret the Constitution as it was made, as how would the founding fathers, um, want us to interpret it, which is, I think, is an interesting idea. The issue with originalism and original idea is to it's very hard to use Constitution as a interpretation, current interpretation of and current affairs. So, for example, if you say gun control, yes, right to bear arms, and people should have the rights to and have that rights, which is the Second Amendment. Um, the problem with that is with the gun control. Are we going to have any kind of gun control, or we're just going to interpret the right to right to bear arms as an absolute right to people to have to bear arms? And the issue, how can we interpret what founding fathers intended? Because the societies that they were growing up and the society that they were living, it was there was no police, so there was no policing. There was this idea of if there's a war, if we go into Britain, if founding fathers were to wage a quick war against Britain or against any other country, neighboring countries or European countries, they would have to be able to be armed quickly, right? So, and since there was no per se a military built, we had militia, and militia had to be armed, and that's where the Second Amendment pertains to right to bear arms, for the militia and all that. But today we have the military, and military is armed, and all that. Now, to arm civilians, it's it's tricky because you do want people to protect themselves, but at the same time, there are people that shouldn't have guns. Um, so this is one of the issues with originalism is that okay, yes, we will look what the founding fathers wanted us to look, but at the same time, times are changing, and Constitution is a living body of elements that living body of rules. That rules have to be stretched and elastic enough to be able to be applied to um, current issues and situations. We could say that the changes and technological changes, for example, like the birth of internet. The birth of internet it has changed how we live and what we do and how we interact with each other. The and the issue is that how would the founding fathers, let's say freedom of speech, control freedom of speech, or control a right to privacy? How did they did not know anything about the internet? So we have to look at the rules. We have to look at and apply them in accordance. But how are these rules um, implemented? So internet founding fathers were not text messaging, or sending emails. They had to write, dip in their little letter and use the ink and do that and send the messages through, by horses and send all that stuff. So the communications and interaction was totally different. In originalist sense of word is that right to privacy, right to privacy. The issue with that is that how the right to privacy, for example, Fourth Amendment says we have a right to privacy, but at the same time you have the internet, you have a GPS, where you have cameras today that almost anybody can be tracked based on the streets that they pass because there's so many streets that have cameras and it can be tracked. So does that, how would founding fathers interpret that idea? Which they had no idea we would have cameras. They have no idea we had cell phones. We have no idea of internet. So these are the kind of issues that originalists have to bear in mind because society is evolving and changing. Um, and I'm not going to talk about are we are less civilized or we are more civilized than what they were when founding fathers were creating Constitution. It's a whole different question. But what I want to talk about is, you know, the ideas, the fundamental ideas that are embedded in United States Constitution. And another interesting idea is that Eighth Amendment, which is right um, against cruel and unusual punishment. But the issue is that cruel and unusual punishment was used in England around 1600s. England actually stopped use the words to argue against death penalty, but not death penalty to abolish the death penalty, but saying that public hanging, beheadings, and that was the cruel and unusual punishment because it's done in the public, and it's also because it was common because a lot of people were beheaded and hanged on a public square where everybody would be cheering on and watching, as we've seen many movies being representing that kind of idea. But at the same time, is the right to bear the right. Um, the Eighth Amendment talks about, for example, no cruel and unusual punishment or excessive force should be used or excessive punishment, which also talks about the bails where when the judge issues the bail and sets up for a poor guy to pay $1 million or stay in jail, and how is the poor guy going to come up with a bail that it's $1 million? So that could be counted as a excessive punishment. So the person has to stay in jail because they're poor, they can't afford it to pay their bail and wait for their trial while they're outside. So the issues that Eighth Amendment touches upon is the idea of what is considered as a cruel and unusual punishment. To have a death penalty, is the death penalty cruel and unusual punishment? Well, historically, we could probably say, well, it's not unusual. We could argue that it's cruel, but it's not unusual because it's done so many times and it continues to goes on today in certain states in the United States. So the language that they intended, that when the right against cruel and unusual punishment, is the fact that cruel and unusual punishment, what constitutes, and this is where the language is very important, is it the lethal injection? Is it the electric chair? Is it hanging? What is cruel and unusual punishment? Or is the cruel and unusual punishment debt by on its own, regardless that is how the state pursues in executing certain people. Is that still a considered um, death penalty as a cruel and unusual mean? So, and this is where the book that I was talking about, the Nine, he talks about how certain justices um, approach death penalty, and he talks about, I mean, it's just that issue, the issue of death penalty, and how should a death penalty be applied among the states? Should it be applied to among the states? So I think the the Nine is a very interesting book. So if anybody wants to read it, I recommend it. Um, so it covers a variety of different issues. Um, so I will be talking about more books, um, different books that I read, pertaining history, pertaining philosophy, pertaining literature, pertaining even teaching, pertaining to any issues or discourses that are historically challenging, and in light of fact today of pandemic and how the government is implementing certain policies. And I could just see a lot of cases coming out suing government for different things that government might have infringed during the pandemic. So that's another interesting question. Well, keep the social distancing, and we'll discuss some more books. Bye.